Gaining some traction in Congress that would make it easier to buy gun silencers or suppressors for those weapons.
42 states allow private ownership of suppressors, but Massachusetts is not one of them.
South Dakota law now includes new protections for firearm suppressor ownership.
Recently, South Dakota passed Senate Bill 2. This is a law declassifying gun suppressors as controlled weapons.
A federal court just dropped a unanimous decision on suppressors, and before that ruling came down, the Department of Justice did something that left the entire firearms legal community speechless. They switched sides. The government's own lawyers walked into court and basically said, "We were wrong about suppressors." And what happened after that? Nobody predicted it. Not the legal experts, not the gun rights organizations, not even the people who have been fighting NFA cases for decades. What the court ultimately decided, and the secret legal strategy that might be unfolding behind the scenes, could reshape suppressor law in America permanently. So let me walk you through every single detail, because the implications here are enormous for every gun owner in this country. Let's set the stage with the case itself. A man named George Peterson from Louisiana was hit with a federal charge for possessing an unregistered suppressor. That charge falls under the National Firearms Act, the NFA, which has been the controlling federal law over suppressors since 1934. Under the NFA, if you want to legally own a suppressor, you have to register it with the federal government, submit fingerprints, pass a background check, pay a $200 tax stamp fee, and then wait for the ATF to approve your application before you ever take possession. Violating this process is not some minor infraction. It is a federal felony carrying up to 10 years in prison. So when George Peterson got charged, he decided he was not going to take a plea deal. He decided to fight. His argument was straightforward and bold. He claimed that the NFA's restrictions on suppressors violate the Second Amendment of the United States Constitution. His case worked its way up through the federal court system and landed at the Fifth Circuit Court of Appeals. The Fifth Circuit is one of the most influential appellate courts in the country, covering Texas, Louisiana, and Mississippi. Back in February of 2025, a three-judge panel on the Fifth Circuit ruled against Peterson. Their reasoning was devastating for suppressor advocates. The court said that suppressors are not arms under the Second Amendment, period. If suppressors are not arms, then the Second Amendment does not protect them at all. No constitutional scrutiny, no balancing test, nothing. The NFA stands. Peterson loses. Case closed. And that should have been the end of it, except something extraordinary happened next. The Department of Justice under the Trump administration filed a brand new legal brief in the case. And in that brief, they completely reversed their previous legal position on suppressors. This was not a minor tweak or a subtle shift in language. This was a fundamental reversal. The DOJ came back to the Fifth Circuit and essentially said, "We no longer agree with the position we previously defended." The government's lawyers wrote that restrictions on suppressors burden the right to keep and bear arms, and therefore those restrictions must be closely scrutinized to ensure compliance with the Second Amendment. They went further, explaining that suppressors reduce a firearm's muzzle blast by up to 30 decibels, which helps shooters avoid permanent hearing damage and improves communication during self-defense situations. Stop and think about the weight of that for a moment. The federal government's own legal team just told a federal court that suppressors have a meaningful connection to the constitutional right to bear arms. For gun owners who have spent years, in some cases decades, advocating for suppressor deregulation, this felt like the breakthrough moment they had been waiting for. The DOJ had flipped. The court was reconsidering. Surely the NFA's suppressor provisions were about to fall. That expectation was entirely reasonable given the circumstances, and the next move from the court only amplified the excitement. The Fifth Circuit panel actually rescinded their original February opinion. They pulled it back. They vacated their own ruling that said suppressors are not arms. Gun rights advocates across the country were convinced the court was preparing to reverse course entirely and strike down the NFA's suppressor regulations. Then the new unanimous decision arrived. All three judges agreed, and the NFA survived. Here's how they got there. And this reasoning is critical to understand because it reveals exactly where the next legal battle will be fought. The court essentially said, fine, let us assume for the sake of this case that suppressors do receive some level of Second Amendment protection. Even granting that assumption, the NFA's registration system still passes constitutional muster. The reason comes from the Supreme Court's landmark 2022 decision in New York State Rifle and Pistol Association versus Bruen. In the Bruen case, the Supreme Court struck down New York's restrictive gun carry permitting law. But in that same decision, the justices drew an important distinction between two types of licensing systems. A may-issue system gives a government official discretion to deny your application for subjective reasons. They can just say no because they feel like it. A shall-issue system, on the other hand, requires the government to approve your application as long as you meet clearly defined objective criteria. You pass the background check, you submit your paperwork. You meet the legal requirements, and they shall issue the permit. The Supreme Court in Bruen said that shall-issue licensing regimes are presumptively lawful under the Second Amendment. The Fifth Circuit looked at the NFA and said the suppressor registration process operates exactly like a shall-issue system. You fill out the ATF form, you submit fingerprints and a photograph, you pass a background check. If you meet all the objective requirements, the ATF approves your application. There is no subjective denial, there is no bureaucrat making a gut-feeling call about whether you deserve a suppressor. So the court held that even if suppressors are protected by the Second Amendment, the NFA's registration framework is the type of licensing system the Supreme Court has already blessed as constitutionally permissible. That was not the result most gun owners were hoping for. But here's the part of this ruling that almost nobody is talking about, and it might be the most important part of the entire decision. The court left a door wide open. The judges specifically noted that they were not ruling that the NFA could never be successfully challenged. They pointed out that Peterson himself failed to present evidence that the NFA actually prevented him from obtaining a suppressor. During the proceedings, Peterson admitted that he simply forgot to do the paperwork. He never applied for a tax stamp and got denied. He never documented excessive wait times. He never argued that the process itself was so burdensome that it effectively denied him his rights. Without that kind of concrete evidence, the court said they had no basis to rule in his favor. That is a roadmap. The judges essentially told future litigants exactly what kind of case could succeed if someone can demonstrate that the NFA's requirements created an actual documented barrier to exercising their Second Amendment rights, whether through unreasonable processing delays, arbitrary denials, or a registration system that functions as a de facto ban. That case could produce a very different outcome. Now, let me get into the theory that is circulating among some of the most respected Second Amendment attorneys in the country, because this is where the story gets really interesting. There is a well-known constitutional lawyer named Mark Smith who has argued cases before the Supreme Court. He has put forward a theory about what the Trump DOJ is actually doing in these NFA cases, and it involves a famous Supreme Court precedent from 2013 called United States versus Windsor. Here's the backstory on Windsor. The Obama administration was defending the Defense of Marriage Act, known as DOMA, in federal court. Opponents of the law were challenging it as unconstitutional. Privately, the Obama administration agreed with the challengers. They believed DOMA was unconstitutional, but they had a problem. If they simply stopped defending the law, the case would collapse. There would be no adversarial dispute, and without a genuine legal controversy, the Supreme Court would lack jurisdiction to hear the case. No case means no ruling. No ruling means no nationwide precedent striking down the law. Mark Smith believes the Trump DOJ may be executing the exact same strategy with the NFA. Consider the evidence. The Trump administration has been arguably the most aggressively pro-gun rights administration in modern history. They pushed through legislation called the One Big Beautiful Bill, signed on July 4th, 2025, which eliminated the $200 tax stamp for suppressors effective January 1st, 2026. That was a major concrete victory. But the NFA itself, the registration framework, the paperwork requirements, The entire regulatory structure, all of that remains intact. So why would a pro-gun DOJ continue defending the NFA in court? Under the Windsor theory, the answer is strategic patience. By staying in the case and maintaining just enough of a defense to preserve standing and keep the legal controversy alive, the DOJ ensures the case can climb all the way to the Supreme Court. Once it arrives there, the DOJ could reverse its position completely, agree that the NFA's suppressor provisions are unconstitutional, and hand the Supreme Court the opportunity to issue a sweeping ruling that dismantles those provisions permanently. A Supreme Court constitutional ruling carries far more weight and permanence than any piece of legislation. Congress can pass a law today and repeal it tomorrow. A future administration could push to reinstate a tax stamp or add new NFA requirements. But a Supreme Court decision declaring that certain NFA provisions violate the Second Amendment would be extraordinarily difficult to reverse. It would set binding precedent for every federal court in the country. Now, nobody outside the inner circle of the DOJ can confirm whether this strategy is actually in play. It remains a theory, but it is a theory being taken seriously by attorneys who have spent their careers litigating Second Amendment cases, and given the sequence of events we have watched unfold, the DOJ's reversal on suppressors, the court's willingness to rescind its original opinion, and the carefully worded language leaving future challenges on the table, the theory has real legs. Let me bring this back to what is actually changing on the ground for gun owners in practical terms, because while these court battles play out over months and years, there has already been a tangible, immediate win that affects anyone interested in owning a suppressor. As of January 1, 2026, the $200 federal tax stamp for NFA items, including suppressors, is eliminated. That fee has existed since 1934. When it was originally enacted, $200 was the equivalent of nearly $5,000 in today's money. It was deliberately designed to price ordinary Americans out of suppressor ownership. That financial barrier is now gone. However, and this is where a lot of people are getting confused, the elimination of the tax stamp does not mean suppressors are deregulated. You still need to go through the full NFA process. You still file an ATF Form 4 when purchasing from a dealer. You still submit fingerprints and a passport-style photograph. You still undergo a background check. You still wait for ATF approval before you can take possession of the suppressor. The only thing that changed is you no longer pay the $200 fee. The paperwork, the registration, and the waiting period all remain firmly in place. Anyone who takes possession of a suppressor without completing the proper ATF process is committing a federal felony that has not changed one bit. Beyond the courts, there is also significant legislative action still in motion. Representative Andrew Clyde from Georgia introduced a bill called the Constitutional Hearing Protection Act. If that bill passes, it would remove suppressors from the NFA entirely. No registration, no Form 4, no fingerprints for suppressors specifically. They would be treated like any other firearm accessory available at your local gun shop. As of this moment, the bill has been referred to committee and has not become law, but it has serious support and real momentum, especially with the NFA already taking hits from multiple directions simultaneously. And the legal challenges keep multiplying. The NRA filed its third lawsuit challenging the constitutionality of the NFA in February of 2026. Gun Owners of America filed a motion for summary judgment against the ATF in October of 2025, directly challenging NFA provisions. One of the largest suppressor dealers in the country has its own ongoing federal case against the ATF challenging the regulatory framework. Multiple organizations, multiple cases, multiple fronts, all converging on the same target. So, here's where everything stands. A unanimous Fifth Circuit panel assumed suppressors have Second Amendment protection, but held that the NFA's registration system survives because it functions like the shall-issue licensing framework the Supreme Court approved in Bruen. The DOJ flipped its position in a move that stunned the legal world. The $200 tax stamp is gone as of January 2026. Congress has active legislation that could remove suppressors from the NFA entirely. and behind the scenes there is a credible theory that the DOJ is engineering a path to get this fight before the Supreme Court, where a single ruling could change suppressor law in America permanently and irreversibly. The fight for suppressor freedom did not end with this ruling. In many ways, it just entered its most critical phase. The next 12 to 18 months could produce legal developments that reshape the NFA in ways we have not seen since the law was first enacted 90 years ago. That's it for today, folks. See you in the next video.